This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're speaking about the fact that people who commit insurance fraud are simply not nice. They are criminals. And when their lawyers attempt to protect the assets of their clients with insurance fraud from seizure by the state, that attempt failed. In the People versus David M. Browne et al., the California Court of Appeals, on May 6, 2025, dealt with some strange moves by attorneys, David M. Browne and George A. Shohet, who appealed from the trial court's denial of their special motion to strike an affidavit filed by the Los Angeles County District Attorney's Office on behalf of the people of the state of California to initiate a contempt proceeding against the lawyers, their clients, and others based on alleged violations of 3 temporary restraining orders that barred the transfer or encumbrance of specified properties and assets. The trial court issued the temporary restraining orders in 3 related criminal actions the people filed against multiple defendants, including the owner of one of the properties, for conspiracy to commit white-collar insurance fraud. The people opposed Browne and Shohet's motion on the basis the filing of the affidavit fell within the public enforcement exemption to the anti-SLAPP statute in section 425.16 subdivision D of the criminal code. Browne and Shohet contended the trial court erred in denying their motion because the filing of an affidavit does not fall within the public enforcement exemption, and the conduct alleged in the affidavit constituted protected petitioning activity. The people moved to dismiss the appeal, arguing that because the public enforcement exemption applies, the court's order is not directly appealable under section 425.16 and dismissed the appeal. In 2015, the Los Angeles County District Attorney's Office charged 15 defendants, including Mr. Turley, who owned the property, with conspiracy to commit insurance fraud, invoking a white-collar special enhancement under the Penal Code, Section 186.11. The trial court issued a temporary restraining order to preserve properties and assets potentially subject to seizure, including a specific property owned by Mr. Turley. The TRO was recorded and subsequently contested by Notre Dame Properties, LLC, claiming ownership of the property and requesting the lifting of the TRL. The district attorney's office filed an affidavit alleging that Browne, Shohet, and their clients violated the TROs by attempting to sell and transfer the property. The affidavit claimed that Browne and Shohet had actual knowledge of the TROs and were involved in actions that contravened those orders, including a purchase agreement and subsequent title transfer. The trial court issued an order to show cause for contempt against the involved parties. The Court of Appeal dealt with the trial court's ruling, which was based on the interpretation of the public enforcement exemption in the anti-SLAPP statute, which applies to actions brought by designated public prosecutors. The court found that the contempt proceeding was criminal in nature, as it was initiated to uphold the authority of the court in enforcing the TROs. Browne and Shohet's appeal was dismissed on the grounds that the order denying the motion was not directly appealable under the anti-SLAPP statute due to the applicability of the public enforcement exemption. The dismissal of Browne and Shohet's appeal, affirming the trial court's decision to maintain the integrity of its orders and the public enforcement of the law. The case highlights the complexities surrounding anti-SLAPP motions and public enforcement actions in the context of a civil contempt proceeding. The Court of Appeals found that the public enforcement exemption applied to the affidavit filed by the district attorney's office, and noted that civil contempt under the Code of Civil Procedure is quasi-criminal in nature, and in contrast to criminal contempt prosecuted as a misdemeanor under Penal Code Section 166, where the primary object of contempt proceedings is to protect the rights of litigants. The proceedings are regarded as civil in character. On the other hand, where the object of the proceeding is to vindicate the dignity or authority of the court, they are regarded as criminal in character. Finally, Browne and Shohet's contention that the trial court did not rely on the public enforcement exemption in denying the special motion to strike was not persuasive, because although the court did not explicitly reference the public enforcement exemption in its oral ruling, the only argument made by the district attorney's office in opposition to the motion was the exemption. The appeal was therefore dismissed. In my opinion, people who commit insurance fraud are just not nice people. They are dedicated criminals. And when they are arrested and subject to criminal trial, they immediately attempt to protect the assets they gain from their criminal efforts. Trying to sell an asset, real property, in violation of a TRO is another effort to profit from their crime. Their lawyers attempted to remove the TRO and were found to be in contempt along with their clients. Their efforts failed because of an exemption from the anti-SLAPP statute applied, and the appeal was dismissed, and therefore, if convicted, their assets, including that piece of real property, can be seized by the state. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week. And you'll also gain access to the more than 5,050 blog postings. You can also please tell your friends and colleagues about this blog so that they too can subscribe to it and the videos on rumble.com or youtube.com. They're all free. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider, for a very small fee, subscribing to my Substack publications. Thank you for your attention.